With my Lord's permission, my Lord's mention item number 27 and 49.
Yes.
My Lords, these are those West Bengal matters we had sought accommodation last week. Mr. Sibal is still unwell. He's leading me in the matter. My Lords, I was requesting for some further accommodation. The learned solicitor, we informed him he's online.
But on this ground, I cannot oppose. Subject to my Lord, Mr. Sibal's health, if it can be kept on 18th, subject to your Lordship's convenience.
18th February?
Yes, my Lord, 18th February.
Yes.
18th
About 18th? Yes. With the consent of the parties, post both the matters on 18th.
I'm extremely
18th.
Yes, 18th.
Obliged all.
Obliged.
Item 1.
Lordships. My Lords, may kindly see, this is an application I filed. The leave was granted in this petition on 14 to 24 by my Lords.
Which
The
matter?
interim order.
Item 1.
इसमें कंटेम्प्ट की फाइल वो सिविल अपील की फाइल भी लगा कंटेम्प्ट.
Yes.
Yes.
Milords,
What is the contempt now?
Milords, what has happened is my Lords were kind enough to initially grant status quo. Then it was
the
confirmed.
orders passed by the High Court,
Yes,
that is at page 45 and 47.
correct.
High Court says that both the parties did not bring it to the knowledge of the GRT.
Yes.
But I was not, Milords, unfortunately, the respondents were parties. I was not made a party also. Therefore, I went to the High Court.
But
Anyway, but
GRT, no.
but the authority was not informed.
How is it a willful contempt? And ultimately, that order is appealable or amenable to challenge in law. You
But
challenge
Milords, my Lord's order of status quo and leave being granted cannot be modified by revenue authority.
It's only a mutation entry. It doesn't confer any rights.
Correct. I agree, Milords.
And
Milords,
our
can
orders will prevail.
Status quo is
Status
for
quo.
possession only. What else?
Correct, Milords. Can I say this, Milords?
If they
Can I request this?
take on ground, then you come.
Milords, can I request like this,
Violation of
Milords?
status quo by settling to dispossess you
Yes.
or create third party interest kind of that, you
Yes.
come, you are not inclined.
Milords, can I say this, Milords? Can I request like this, Milords? Can this be kept along with the main
No,
matter? So,
it will not be kept pending.
Milords, then can I say this?
Counsel for the petitioner, we are
Milords,
not
then
inclined.
I'll withdraw at this. Milords, I'll withdraw at this stage. You raise my objections at
What
an
is the
appropriate
stage?
stage.
If today it is not contempt, tomorrow also it will not be contempt.
No. If any,
Same.
Okay.
It is not. If they do any other act which amounts to violation of our order, you are still free.
Always.
I'll withdraw on this ground. Milords, Lordship may say so. I'll withdraw on this ground because this is a revenue authority.
Current counsel for the petitioner seeks permission of the court to withdraw the contempt petition at this stage, accordingly dismissed.
Please.
Item 2.
Yes.
My Lord, there's some delay in filing this. There's some delay in filing this SLP.
391 days.
Some delay.
Yes, there's a case.
Some delay is
Group
2 figure, not 3 figure.
D employee, my Lord.
Hmm?
Compulsory retirement, my Lord.
Yes.
May see the charges, my Lord. Charges are very simple, my Lord. One day of unauthorized leave and
Rude behavior, threatening, assaulting, abusing.
Everything, insubordination.
that I've given railway concession forms without permission of the principal.
And rightly set
1,000
aside.
rupees penalty is given, my Lord. I was ready to pay the 1,000 rupees penalty which was imposed on the management. My
No,
Lord,
it was rightly set aside by the High Court duty.
my Lord, tribunal has exonerated by going through the
Tribunal acted as if the tribunal is the inquiry officer, which is not permissible and rightly said so by the High Court.
My
Both.
Lord, last submission, my Lord. Before the learned single judge, the management was ready to settle the matter by offering me some amount, my Lord. At least on that point, my Lord, because today
No.
I have not received
You should have done it.
which after
You
27
should have done it. Before the single judge, you should have done it.
Compulsory retirement, you will otherwise also get retirement benefits.
until today, I have not
Dismissed.
received any benefits, my Lord.
So that is a separate cause of action.
Dismissed. Delay condone dismiss.
2580 days delay, sir. 2580.
Swami number 1 is a post-vesting.
What about the
Delay.
That's a 7 years delay.
Only.
Not only.
There's a presumption that a man has died if he is not seen for 7 years.
sorry, Manoj, but Manoj,
You are also a juristic person, you also died.
changes, Manoj.
Thank you. On the ground of delay, dismissed on the ground of delay.
Manoj, the delay, Manoj, it is a settled law that the post vesting
By so and so.
purchasee cannot take the land, Manoj.
Why you are cognizant enough?
And in
People is
between,
sleeping.
in a dispute between the respondent number one and other respondents, why state should file SLP?
Manoj, because the land was vested with the state in 1982.
No,
Manoj,
no.
by the
Yes,
because
next,
it's cognizant.
on the ground of delay. 7 years, who will condone?
Item 4. Lordship, in this case, I am a petitioners are the mortgagee. After that.
You were never recorded as Bhumidhari.
Never.
Lordship, I am possession law is still now.
I could say, and all the authorities say possession is not with you.
Not with you.
Lordship, possession
That is
is with us. I can show the Lordship in this case what happened. No rejectment.
You are only a mortgagee, you are trying to
Step into the shoes
step
of the
into,
owner.
yes.
That's why I'll show. As on today also, there's a latest
There are
order.
4 concurrent findings, madam. This is 136. There's no
And see,
question of it.
High Court's finding in para
6,
10 and 11
12 and 13 years.
that you are not in possession.
Lordship, this order is nowhere on the record.
High Court order is on record.
Lordship, not.
Dismissed.
Even
Dismissed.
in the high.
There is nothing, absolutely.
Fine. Lordship,
Yes.
kindly see the count.
The mortgagee not in possession, dismissed.
Item 5. But
Yes.
no eviction, Lordship, I'm saying.
Alright then.
We are not saying anything. We are not saying
I
anything.
am not able to produce
We
a
are not directing for your your eviction. If you are in possession, enjoy it. Yes. Next. Yes.
13, 11 days delay, sir.
I must
17
have delayed filing the SLP news.
Yes.
Was the issue was the
Issue is delay.
yes was
Unexplained delay. That is the issue which you have answered for.
And you are squatting over government land,
Yes,
Tamil
but-
Nadu land, and since long 1993, make way for the panchayat.
Look, may I submit logs?
To manage the land.
delay that 13 section title suit is still pending. Now there was an issue with respect to that judgment,
Dismissed on the ground of delay. Yes.
like this.
Yes, go and fight it out. Water body,
Water
government
body-
wants to use it for public purpose.
I seek permission to withdraw the petition.
Yes, well advised.
Final order has been passed, shall I seek liberty?
No liberty at all.
Final order has been, this
If you have liberty in law,
Final order has been passed.
now passed.
The counsel for the petitioner submits that since after passing of the impugn order by the High Court, the writ petition itself has been disposed of. Accordingly, he seeks permission of the court to withdraw the writ petition, withdraw the SLP as it has become infructuous, with liberty to challenge the main order passed in SLP. Yes, accordingly dismissed with the liberty aforesaid.
Item 7.
Wait, please. So the issue before the High Court was only seeking continuation of delay. So the allegation was-
Only 8 years delay.
only yes.
Only 8 years delay.
No, but what happens is this, he was suspended. But after suspension, the termination order was never communicated.
Thank you.
Only one thing, Your Lordship.
Dismissed 8 years.
No, but Your Lordship, please see this what they do is, they initiate a formal inquiry. Formal inquiry is not even contemplated under that. Under the Act, they could have initiated department inquiry. Well, there is no department inquiry. What they do is,
You should have challenged that order in.
Yes, next.
Item 8.
Well,
8, please, my lord. Yes, I'm aggrieved by the transfer order, my lord. Posted,
Don't work. You can resign.
Yes.
That option is always available to you.
my lord, I'm paying medical bills.
Absolutely nothing. Sorry.
You
I
have
will not entertain SLPs like this.
you have worked there for 6 years, 2019 to 25.
They Mitra, my lord.
Ah.
Then now, my lord, I'm transferred to Jashpur.
Yes, Jaspur is also in Chhattisgarh.
You have the option of resigning and continuing whereas per your sweet will.
Yes, sorry, thank you. Dismissed.
Item 9.
My lord, I'm paying a short pass over.
Which matter?
Item 9.
9.
Item 10.
Your Lordship.
Yes.
That's a concurrent finding has been disturbed in revision on a mere assumption that there is some material on record, some material which the single judge says.
He has never been served. That is the finding of the High Court,
That's the
that the defendant was never served with the summons.
No, Your Lordship, we kindly appreciate this, madam.
What appreciate? You read the order.
Yes. Your Lordships may kindly consider, my lords.
And you participate and convince.
No, the Lordships may kindly consider, my lords. The trial judge says serve. The appellate court serve.
Service by out mode was ever someone sent by ordinary process? Admittedly, no.
No.
Registered courts, they were
No.
The CPC requires service through
First service through ordinary.
Then
If it fails, then registered. From day one, you cannot serve by registered mode.
When the registered process is also refused, that is in your hands.
The Lordships may kindly consider what Order 9 Rule 13 stipulates, my lord.
It is only at 40 degree you will still have the chance to prove your case in the trial.
Consider this, my lords. Postal.
You will be dismissed.
Thank you.
Dismissed.
Postal
We don't encourage at 40 degree if the summons is not served in accordance with CPC. Next.
Item 11.
Sector.
Let us adjourn.
Item 12. Item list. Next.
Your letter, probably, you are not aware?
She announced immediately. Item.
Yes.
But in the second earliest taking order,
What happened after the impugn order?
21/7/25. You have got opportunity to argue on charge, everything. You raise your objections at this stage of charge.
Notice was made returnable in 6 weeks by the High Court. What happened thereafter?
nothing has happened, Lord. No.
Nothing to go and convince him.
Go and argue the matter on merits.
Lord, page 47, if my lord may say.
You get a rejection on merit.
8%. Lord,
You get
In the
order on
in
merit.
the order under challenge in this SLP, the High Court has not decided any list or issue between the parties. Therefore, we are not inclined to entertain this SLP according to
Lord, it will be rendered infructuous.
No.
Doesn't matter.
Huh?
Lord,
You always have.
my question petition would come infructuous, Lord.
You argue that and convince. Yes.
Item 13. Possibly short pass over.
Okay.
That's item 49. And this is a question petition which was not entertained by the High Court.
Rightly so. Application of public records.
But my
You
lord,
can't settle by compromise. Sorry.
And it is not at your sweet will. Someday you will do FIR and someday you will compromise.
may I submit, my lords? My
The property of a person, living person, was sold by showing him as dead.
my lords, it was first mutated.
Fabricated mutation entries.
Rightly, it's an offense against the
And
society.
the alas, the name and the parentage is same. My lords, the mutation officers, the tehsildars, the patwardis.
You are not being convicted. Go and
Later,
face trial.
on the objections, they reverted in and then I entered into the
Dismissed.
compromise.
Nothing. Yes.
My lords, next. The matters
No, we have seen, both of us have seen, and we are on the same page. Yes.
the parentage was seen that created the confusion, my lords.
You have a opportunity of arguing on charge. Go there.
Yes, next.
Investigation is pending, my lords.
So all right, it will charge.
Whenever charge sheet
Convince the
is
IO
filed,
not to file a charge sheet. Thank you.
Item 46.
Well, 3.5 years the Sunday trial has suffered, and both the two courts have not
You
discussed.
had 7 antecedent. Stabbing, CCTV, eyewitness, everything is there.
But for 4 years he has been suffering. Only 4 witnesses have been examined. 25. Only 4 witnesses have been examined, my lords, in this case.
46 count.
Yes.
46.
I'm sorry.
Yes.
Just a minute.
Yes.
Oh, yeah, this is available.
Your lordship will give me some matter 3 minutes, my lords.
The trial will be expedited, don't worry.
No, my lords, in 2020.
There is one deceased, one injured.
My lords, I will come to those
Stabbing is a very cowardly offense.
Yes. Deceased and the injured witness is contradicting first
You have
informant.
7 antecedent.
In fact, it seems first informant is involved. He was the rickshaw driver.
Sorry, dismissed.
Sir, your lordship, please hear me for 3 minutes.
Dismissed.
No, my only request was I may be heard.
So you want an order on merits? Prejudicing the trial, please?
No, but at least
We are not convinced, Mr. Counsel. There is a matter of discretion, sorry.
my only request is that my submissions may be heard, my lord.
All right, we'll note your submissions then. And deal with them. At this stage, you are inviting a conviction order. Do that.
Because in 2023, High Court had granted me liberty to move Sessions Court if trial is not progressed. I go before the Sessions Court. Sessions Court says no, the matter should have gone before the High Court only. And then when I again move the High Court, there is again no discussion how long the
Considering that there is evidence of eyewitness,
no, yes,
amount of the injured eyewitness, CCTV footage,
No, Malas, I am not denying.
Against the petitioner who has allegedly stabbed the deceased on his abdomen.
These are the statement of the
And
injured
moreover,
person at page
petitioner has
45.
7 criminal antecedents to his credit. We are not inclined.
Malas, page 45, your lordship may
We are not inclined to entertain this SLP accordingly. SLP is dismissed. Yes, next.
My humble request, at least a report will be called from the trial. How long the trial?
Over, it is over. Next.
Item 47, it is for suspension of sentence and for grant of bail, Your Honor. Arrest order detected.
Dead body was recovered at your instance.
Grave offense.
Dead body was recovered at your instance.
Your Honor, but the only
For an early hearing of the appeal. Earlier appearance, physical appearance.
This is a fresh matter, Lordship will
In 46, you are saying?
Yes.
Lilin. Yes,
Very grave case.
yes.
Your Honor, my CDR location was not found there.
You argue the
Argue the appeal, argue the appeal.
Your Honor, kindly give us that we will want to file additional documents. We
don't need, Mr. Counsel. These documents are sufficient to convince us.
Dismissed.
Item 48.
Your Lordship, I have been under judicial custody since the 9th of
In 4 weeks.
Lords, I appeal to the state, Lords.
Post on 11th March.
Lords, my
Yes.
appeals will be kindly taken.
11th करना.
State of the art.
18th March. 18th to 19th. Yes. Physical appearance.
Yes.
Physical appearance gives notice on the test to file. Yes.
Lordship, in item 15, Lordship issued notice and last hearing, state has asked for time to file reply. But
Yes, state. Passport.
Milord, I need short accommodation, Lordship. I have received some injury. I could not file it.
You are appearing in 15?
Yes, Lordship. I am for the state. I received some injury. I could not file the counter. I am instructed that there are several criminal antecedents against this.
1 week or 2 weeks? What?
3 weeks, Lordship. Give me 3 weeks time, Lordship.
Why 3 weeks? 2 weeks.
Okay, Lordship. I'll file it.
2 weeks for counter.
16.
Yes.
Your Lordship, this is a case for extension of medical bail that was granted.
Any counter is filed?
No, Your Lordship.
The counter was filed against the bail application. No counter.
No, in this SLP, further extension is sought.
Yes.
And my lords, I have
You should place on record his current medical condition so that we decide.
My lords, I am representing the victims. This was a firecrackers factory blast that
We know, we have
I
discussed.
filed an impediment application 42645 that will be taken on record. I've also filed my reply, my lords. That may also kindly be taken on record.
This is an indulgence only on medical ground.
Yes, my lords, the challenge is I was heard by the Supreme Court. Even
When have you filed this impediment?
we have already filed, my lords. It's
Already means tomorrow, yesterday or day before?
Yesterday, my lord.
Yesterday it may not be.
But my lords, it has already been cleared by the registry. I have the
Come up.
Yes, very well, very well.
Deciding the matter today.
Yes, very well.
Yes. Let.
File the present status report.
Let.
And we also filed a reply, my lords.
Let respondent state of MP file counter affidavit mentioning the present medical status of the medical condition of the petitioner.
Great.
Yes.
Your lordship, at least my employment may be mentioned.
Yes, yes. So learned counsel submit that she has filed
IA number 42645, my lord.
IA number
42645
seeking impediment.
Along with the reply.
Let the impediment application be also posted for consideration on the next date of hearing.
Also, short date may be given.
Short date what?
Your Lordship, in the meanwhile, the interim may continue.
9th March. Interim bail. In the meanwhile, interim bail allowed in favor of petitioner shall continue till the next date of hearing. Yes. Yes. Yes, Mr.
Where is the 164 statement of the girl? 183.
That is not.
You already filed an affidavit.
Victim has already
Declined. On the bill of the victim is here. Yeah, he will also support. You are supporting?
High Court minutes, she has filed an affidavit.
All right.
Yes.
You are aware.
That medical report is also in my.
Forget about medical report.
It is only for that.
She is married.
We pleaded the father of the prosecutor so that we know whether at all
The affidavit was under
the affidavit was under pressure or it was free from pressure.
Yes. She is married.
Concede, we have heard the counsel, Mr. So and so and counsel for the petitioner, Mr. Anand.
Yes.
Then counsel for the petitioner and Mr. So and so for the state and Mr. So and so as well appearing for the respondent number 3, father of the prosecutor.
Victims.
With the victim, father of the victim. Poster. Considering the entire fact situation of the case and the flip-flop
Item 18.
Your Lordship, I beg to appeal for petition, yours. Because I was acquitted of the POCSO charges.
Yes.
I have been convicted under 3.
So they were in relationship for 2020,
4 years.
2024.
Continuous romantic relationship.
Yes.
I'll leave it.
Same age group.
Yes, petitioner has been convicted. If we leave granted. Petitioner has been convicted for committing offence under section 376 within bracket 2 within bracket small n on IPC and has been sentenced to undergo RI for 10 years. There is no conviction under POCSO, no?
No.
Full stop. Under the impugn order, the High Court has refused to suspend the sentence and enlarge the petitioner on bail. However, considering the material on record, we are of the considered view that the present is a fit case for suspension of sentence imposed upon the petitioner and directing his release on bail. Accordingly, the impugn order is set aside. Criminal appeal is allowed and the petitioner is directed to be released on bail pending appeal before the High Court. Suspending a sentence. The petitioner shall cooperate with the hearing of the appeal before the High Court. We are of the view, sentence पढ़ना है.
We have the considered view वाला.
वो पूरा पैराग्राफ पढ़ना.
Accordingly, the impugn order is set aside, criminal appeal is allowed, and the petitioner is directed to be.
उसके पहले.
We are of the considered view that the present is a fit case for suspension.
On the considered view, on the length of jail sentence already suffered by the petitioner. And other attending circumstances. Yes.
Lordship may kindly record it was consensual relationship on the pretext of.
Oh, forget about it. You want a decision of the appeal at this stage? Let the High Court have its discretion.
Yes.
Great.
There was some delay. There was some delay in filing the SLP.
Delay.
19.
Yes.
Manus, I am appealing for the state. We are seeking some time to file counter.
But complaint is issued complete complaint. Though you are enjoying interim order, we have granted.
Yes.
But since your statement was there that they have compromised.
They have
and he has received the entire amount. Complete the complaint so that he is here to confirm your statement. Let the complainant be made a party respondent in this SLP. Counter affidavit be filed and notice is issued to the complainant. Memo of party be corrected. Learned State Council is allowed 4 weeks time to file counter. Post the matter on 23rd March. Interim to continue.
Item 20.
Yes. 21 of first state. This is a matter of
20. Yes.
There is not a single eyewitness of the alleged incident, my lord.
Hmm?
But there is not a single eyewitness.
Not a single eyewitness.
Second, that motive is also not proved, and I am implicated only on the basis.
Antecedent, including 302.
Yes, only on that
Including
basis.
302.
Only on the basis of that antecedents I am implicated in the matter. The second aspect of the matter is that all the that
CCTV is there. You were roaming around.
So 5-8. 20,000.
What is the distance between the place of occurrence and the toll plaza?
That distance?
Yes.
That distance, I am not aware about that.
You have to make a statement on that.
But that second aspect of the matter is this: only on the basis of antecedent, the police authority implicated me in the present matter. I was taken into custody on 5-8 on the basis of that CCTV footage, and that produced me after on 9th. The remand report is very much clear. That is the another aspect of the matter.
What is the remand report?
Remand report said that on the basis I was moving suspicious on the toll plaza.
Where is the remand application?
Page 41 is 39 starts, madam.
Yes. What do you want to read from that?
41 second paragraph, madam. While local police crime branch so and so, and we along with our subordinate police staff were investigating the said crime, an individual named petitioner was seen under suspicious circumstances on a motorcycle on 5-8 near the tea stall at the toll plaza on the way from Pune to Nashik. Upon further questioning, he gave evasive answers. As suspicious grew, he was taken into custody and brought to the police.
On 9th.
Taken into custody on 9th.
They are showing that they on the arrest form, my lord, they
9th August.
Yes, 9th August. But I was taken into custody on 5.
So it's a case of 4 days illegal custody.
Yes.
He was not taken into custody on 5th.
He was confined on what ground for 4 days? Did you release him?
Lord, he was taken into custody on 9th, not 5th.
Read page 41, Mr. Counsel.
41 says
when did you release him? Read page 41.
Lord, 41 says what my learned friend has read there.
Yes, read that.
Lord,
He has taken a specific plea.
Where is the fact mentioned in this that he was
Released on after
he was detained on 9th, not on 5th. Detained, not arrested.
Detention is on 5th August. You continue to keep him confined for 4 days.
But this says on 5th, on the basis of CCTV, he was moving around on 5th.
Detained. Read please page 41.
While the local crime branch Ahmednagar and we along with the subordinate police staff were investigating the said crime, an individual named Bhushan Wale was seen under suspicious circumstances on motorcycle on 5th so-and-so at 3:30 am near a tea stall at Toll Plaza on the way from Pune to Nashik. Upon further questioning, he gave evasive answers. As suspicion grew, he was taken into custody and brought to the police station. Upon questioning him in confidence, he confessed.
What is this date? He was taken into custody.
When was he brought
What
into
is this
the
date?
police station?
Lord,
From 5th August, 9th August, they have taken a specific ground.
Lord,
What have you replied?
Lord, as per my instructions, my Lord, he is.
Does the document read that he was released thereafter and was asked to come
You
back on 9th?
satisfy us that he was taken into custody on 9th itself and not on 5th.
The document itself reads so. Where is your ground, Mr. Counsel? To this effect that he was kept in legal custody.
Yes, page 4 of the inquiry note.
Yes.
Para 4.
Yes.
Learned advocate for the appellant submits that.
What is your reply to this?
Non-communication of grounds of arrest for 4 days.
Yes.
Yes.
But I have stated that he is taken into custody on 9th itself.
What were you doing with him since 5th to 9th, Mr. Counsel? That's what we are asking. How was he kept confined for 4 days without preparing an arrest memo?
Yes, what has...
But he was not confined. He was arrested on 9th itself. Lord.
What were you doing with him from 5th? Please, your document remand form says.
Specifically, page C, last paragraph, petitioner was taken into custody on 5/8. What is your reply to this? Because the remand was taken on 10/8. That means he was arrested on 9th.
Arrest memo itself is
From 5th to 9th,
he was in illegal
he was in
custody.
illegal custody, and you have not replied to this specific
And grounds of arrest, nothing.
Lordship grants me weeks time.
No, no question, this question, sorry.
Check. Third and counsel for the parties. Considering the material on record, and for the fact that petitioner is in custody for more than 1.5 years, we are inclined to release the petition on bail, accordingly dismissed, accordingly allowed.
Great.
Seeking a short passover in this matter, Your Lordship. We are led by Senior V. Giri. He's on left.
Yes.
Passover.
Awesome.
Item 22.
Point 2 to 4.
Yes.
Mail. Sorry. Because while issuing notice, please see the order which has been passed. Okay. 29-4.
You want to argue? Come on merits.
No, on merits only, my lords.
Yes.
On merits. Please come to the order.
No, you convince us.
Just 1 minute.
You are a developer.
No, my lords. I am the original owner. Please come to 29-4 for a minute, my lords. My lord's order. It is the contention.
You will not argue.
No, I'm arguing, my lords.
Yes.
It is the contention of the petitioner that the award notice was defective and the award is passed beyond the stipulated period of 2 years. Delay condoned, issue notice, etc. Now, it was my specific, my lords have the 29-4 order.
Yes.
Now, it was my specific case before the High Court that the award was 2 years beyond the Section 6 declaration. And therefore, but the whole thing lapsed under Section 11 capital A. Specific ground was taken. No specific answer for that issue. In fact, that ground, if my lords will see, is that in the writ petition.
Which order you read?
29-4, 2024 of my lords, while issuing notice.
May I pass on?
First paragraph, lords. It is the contention of the petitioner that the award notice was defective and the award is passed beyond the stipulated period of 2 years, delay condoned, issue notice, etc. Now, this ground was specifically taken in the writ petition. Please come to writ petition at 99, specifically the grounds at 108. Please come to that for a minute, my lords. 99 it starts. Act, my lords, 108, para 16. Bottom of para 16, the award notice, last line, my lords, last 3 lines in fact.
Yes.
Is also defective and the award is passed beyond stipulated period of 2 years, which again is contrary to 11 capital A of the Act. Now, apart from this,
What is their answer to this?
No specific answer to this.
Let us see the counter first.
Yes.
The writ petition.
Yes.
Yes.
Now, please.
Because the High Court has not dealt with this.
It has not. That's why, my lords, we specifically pointed it out. One more aspect. I also raised the ground that the time period between 4 and 6 also there is a delay. That is not taken note of by the High Court and they deal with that. Now, please come to page, the impugned order, page 23. It is to be noted, last paragraph. It is to be noted that no other ground is urged seriously, but on going through the learned single judge's order, the petitioner has taken a contention that the final notification is not published within the time prescribed. Single judge has considered the same at para 10 of the order, taking note of the fact that the publication at Satur village by the revenue inspector is on 16/12/2010 and final notification is on 15/12/2011 and rightly held that the final declaration is within the time prescribed. So, of the 2 points raised by me, the first point with regard to 4 and 6 is looked at. Now, please see what they say in the counter before my lords in respect of this point. Please come to that. For the first time a document has been produced and High Court has really not looked at it. And we have not had the opportunity to rebut it. Therefore, perhaps appropriately it may be a case for to go back to the High Court.
Not go back. We'll decide here itself. You file or reply to this. If they have filed it now,
yes,
you can file additional affidavit.
Sorry to interrupt. May I just point out?
I want to point out something.
I'll answer on merits. It's covered by a lordship's judgment, but this is not even a ground raised in the SLP. Although because it was there in the notice, order issuing notice, we have referred to that. The single judge, my lords, refers to this argument at page 151, rejects this argument. Before the division bench, it appears to have not even been raised. In the SLP, in the grounds, not a single ground on this. While issuing notice, this they appear to have taken this. Please have page 151 first, and covered by a lordship's judgment. I'd show the judgment straight away.
Can I then point out their objections before the High Court?
Page 150, bottom of the...
If you wish to file any additional
There is a
affidavit,
specific
then
ground.
file it.
I will file, my lord.
Otherwise, don't waste time and then after 10 minutes you will say, allow us time.
Very well, we'll do that. I'll do that.
Your lordship is referring to page 23.
Wait a minute.
In view of the additional document filed by respondent, the learned counsel for the learned senior counsel appearing for the petitioner takes time to file additional affidavit. Accordingly, post the matter after 4 weeks.
We'll do that.
Post the matter did on 10th March. Sorry, 19th March.
I'm sorry, is there anyway? That ground is there anyway? I'll show your lordship. It's covered.
I didn't want to say anything.
It's covered by your lordship's judgment. May I make one request, though, my lords?
May be covered, but since he will take time after half an hour, we know.
May I then make one
That's all the
request?
argument.
This entire project of about 250 houses is stalled because of this. 2,500 houses is stalled because of the stay.
We'll hear it next.
Some date if your lordships.
My lords,
Date already given 19th March.
yes. I am reserving myself on the last submission also, my lords. We are disputing it. Anyway, my lords, I'll file my affidavit and we'll argue, my lords. Yield obliged.
My lords, if you permit me to submit hard copy of the appearance, my lords, for item 22.
Why hard copy?
My lords, names of two of the my lords, name of one of the seniors, my lords, was missed on my part, and the attestation.
Item 23.
Yes. Santosh Kumar had received on 13/8/2019 suicide note. Where is the suicide note? As for the suicide note, my lord.
No, sir, we have produced original version of suicide note. It is on page number 13 of counter affidavit. Mistakenly, he wrote Varun Singh.
Even if we consider the suicide note on the face of it, whether it is
What is the abatement? How will it constitute abatement?
He is clearly
That is 11 and 12.
he was being harassed by these people.
So he expected some monies, or some monies were due to the accused, due to be paid to him by the accused. So he should have filed a civil suit.
But this
How it is it? How it is abatement?
It is Varun Singh.
It's Varun
Varun Singh.
That is what prosecution story is, that he mistakenly wrote Varun Singh instead of Varun Singh, and all the other who accused.
Contents of the suicide note is मुझे इससे इतना लेना है, मुझे इससे इतना लेना है, मैं रेत घाट से परेशान हूँ, परेशान वाले के नाम इस प्रकार है. So many lawyers are really perturbed because matters are not taken up. What to do?
Page 30, Hindi version.
That's what we are reading. That's what we are reading. Irrespective, even if you had been named.
Even if it is your name. And rightly named. No suicide note.
This doesn't constitute a suicide note at all, as a matter of fact. हिसाब किताब बाकी का करना है और कुछ नहीं.
Diary. It is diary entry.
हाँ, diary entry.
Yes, where is the ingredients of the?
He has not clearly stating that.
मैं सर मैं मन से परेशान हो गया इसलिए मन से आत्महत्या कर.
अपने मन से.
Paragraph 14
page 30. मैं अपने मन से आत्महत्या कर रहा हूँ. This is Hindi version.
So
outstandings exceeded his capacity and therefore he's committed suicide. What to do?
Because he was being harassed.
No. Because he has business transaction.
in upper portion of this note, he is clearly saying that he was being harassed by these sets of people, and at the bottom he is saying that he is committing suicide.
We will pass a detail out. Allowed.
Lordship, I allow to give the appearance slip in item 16, I agree.
Item 16.
Yes.
Item 24.
Also, I'm seeking a week's accommodation in this matter. My colleague was arguing this matter, unfortunately had some personal difficulty today. She could not appear.
2 weeks.
Item 25.
I am appealing for respondent number 3 and 5, the state of Gujarat in this matter. Milord, we have preferred and one SLP in this matter. It's showing a date of 13. Effects are clear. Most likely it will be listed on 13. Let that main matter, this matter come along with this matter.
13th before us or before some other groups?
That's the same similar matter. This is the union's SLP. State of Gujarat.
State diary number. Diary number.
5138 of 2026.
Learned counsel for the petitioner submits that.
Well, it's, they're appearing for the state of
State of
Gujarat.
Gujarat.
I'm appearing for Union of
May I submit?
You should have appeared this side.
In that case, state of Gujarat is the appearance. Before us. It is the same.
But who is the petitioner in this case?
Yes, I'm appearing for the petitioner Union of India in this matter. We've been helped by the learned solicitor general. Now let's take up both the matters.
Learned counsel for the petitioner submits that state of Gujarat has also preferred SLP diary number
5138 of 2020.
5138 of 2026. Again, the same implement. Tag with so and so.
Lordship, I am appearing for Gujarat Karamchari Anganwadi Sangathan, Lordship. I was implicated as a party before the High Court, Lordship, but I was not made a party here, Lordship.
You file impleadment.
I file impleadment. Record my appearance, Lordship. Permit me to mark my presence.
You are not yet a party.
Lordship, I was implicated as a party.
You are not yet a party in this assembly. How can we take your personal?
That matter is still, notice has not been issued in that matter. That matter will come up on 13. So, Lordship has stated that it is to be tagged in the order.
That will be tagged instead automatically on the date which is its schedule.
Yes,
What else are we supposed to do?
Then what shall we write?
That
What shall we dictate that so and so has been filed? It will come up on 13. How do we know it will come up on 13?
Lordship, the private respondent have filed reply affidavit yesterday.
ऐसा करना tag with me करना. Also file so and so. Post matter after 4 weeks.
Lordship, pleadings may be completed from the government side in this matter. The private respondents have filed reply affidavit yesterday.
If they want to file counter result, they will do it.
Yes, next, call the next case.
Item 26.
Right.
Because in item 26, we have been served with the counter on Saturday because we are seeking short accommodation to seek instructions in that. And
how much? 2 weeks, 3 weeks?
2 weeks minutes.
2 weeks.
And we don't be posted at any NMD for final hearing works.
Yes.
Item 28.
बस 2 weeks कर जाएगा. फ्रेश कैसे हर आदमी को तुरंत चाहिए. और पूरे जरूरी है.
So,
yes, ma'am.
सर SIT ने जो भी रिपोर्ट फाइल की है, मैं अपना रिप्लाई फाइल करना चाहती हूँ, क्योंकि इवन
खत्म करिए इसको, क्या कंटेम्प्ट है.
सर मजिस्ट्रेट ने भी डायरेक्शन दिया था कि झूठे जो बयान दिए गए हैं वो आपने उसका स्टेटमेंट वगैरह नहीं लिया, और मैंने इवन यहाँ पर भी सबमिट किए काफी सारे डॉक्यूमेंट, एडिशनल डॉक्यूमेंट्स में, जिसमें झूठे
conducted the investigation, my lord.
No, sir, let me speak.
He wants to file some.
क्या फाइल करना चाहती हूँ आप?
Objections against the statement.
22 की FIR की इन्वेस्टिगेशन
IT report has been filed.
और इसके अलावा
appearing in person wants to file objection to the SIT report. Post the matter after 8 weeks.
Yes.
Item 29.
Post the matter on July on 28 July.
Lordship, this matter is at the board of settlement. Now it is. Listed for mediation for signing of agreement on 11th March, Lordship.
On 11th March it will be signed.
Yes.
Yes.
We'll post it after 23rd March. Post on 23rd March. At the joint request of London Council for the parties, post on 23rd March.
Item 13.
Please for the yes.
Readings are complete in this matter.
Readings are complete.
Yes. Now kindly see my, I filed my counter.
Seeking transfer on what ground?
Seeking transfer on the ground, so the already 4 cases are pending.
4 cases are pending.
Yes, sir, in the Rohtak jurisdiction. Yes, sir.
May kindly say one more thing, Malik. Before transfer, Malik, the petitioner is appearing here.
Alright, you are also appearing in Rohtak.
The problem is, Malik, I can't appear there because Malik, here she is appearing.
But you have not filed any transfer petition. You can transfer of Rohtak proceedings.
No, Malik, I have not filed.
Appear virtually.
If you can't appear,
she can appear here.
Alright, you can appear there also.
15,000 I am paying, Malik, I will be harassed.
Four other proceedings between the parties are
in mediation.
We are inclined to allow this present transfer petition.
In mediation, she said, I don't want to give you divorce, I don't want to live with you.
That is her problem.
Yes.
Contest.
May I please, Lordship, there are 2 transfer petitions. One is filed by the wife and this is the second one which is filed by the husband. Now, Lordship was placed to issue notice. Lordship, in the early transfer petition that has been referred to the mediation while Lordship's order dated 29 January 2026. I am just praying that this petition will also be tagged with that. And
is the ROP of the other matter?
Please, Lordship, I am having. This is the order copy. And it is also mentioned in the office report.
P3. Election P3 is. See my head, I am election P3.
In TP civil number 2410 of 25, between the parties have been referred to mediation to be conducted by a Supreme Mediation Center. At this petition with the civil number 2410 2025 and the orders referring the parties to mediation shall also apply in the present transfer petition.
Clear.
Item 32.
Lordship, in this, the advocate is appearing before other courts, so we are taking fast.
Requesting for a passover.
Appearing in other court.
Sybil is here.
He is here.
Respondent for 2 minutes as per the last order asked to file a counter minutes.
Who is respondent number 2?
Lordships, I am appearing for respondent number 2.
Yes. Your file counter?
No, your Lordships. Lordships may grant me time for 2 weeks.
She is ready to argue without evidence. They accept me for the last date.
Yes. Are you ready to argue?
Lordships may grant me a short passover, your Lordships.
Passover? You will come here or what?
Your Lordship, my colleague is there in physical.
Alright, so are you ready to argue or not?
My colleague will argue, your Lordships.
He is here, then why do you want a passover?
Not in this.
Milords, I have a certain difficulty. Milords, for my daughters. If Milords can have it next time. Sorry,
Learned counsel for respondent number 2 passover. What? You are for 1? 2 passover. However, learned counsel for the respondent number 1 has some difficulty.
Your Lordship, my colleague is here.
I don't have Milords.
The present state is a complete.
He is also
here.
He is also here.
But he is here.
Yes. He's with Rafi.
My file, the clerk is getting my file. We'll also pass it over.
He's here.
Clerk is also here.
So sorry, Miss. Please have page 159 minutes.
Yes. You don't want the petitioner to argue the case?
No, I'll leave it at that.
Then?
Yes, Mr. Nagamat.
If they want further, you have to kindly pass or I will do that, I am ready. We can go ahead, Minister.
We don't know who is seeking password, either you or respondent number 2, respondent number 1.
No, I am not asking for. I am not asking for.
Yes, now he is ready. Yes.
Ready? Yes. Let me tell you. The case
And 138 is pending?
Yes, my it is pending.
Yes. And it is this same transaction. Same transaction.
Yes.
Both the matters be tried together.
What's up?
Yes, both the matters be tried together.
What's up? I will show what I say. How?
See, what is his defense is your offense and your offense is his defense.
After 138 after he appeared, he made a complaint. Police inquired into. Police found that there is no proof.
Suppose their defense is accepted and your 138 fails. And if in the meanwhile we cross this trial, then what will happen?
Perhaps this has to be quite. The reason is this. Muratma kindly consider. He made it.
The trial is stayed. This trial has been stayed. Yes. Leave granted. Post for final hearing in due course. The interim order shall continue during pendency of development. Yes.
It won't come in the near future.
Let it be. You
prosecutor. In the meanwhile, 138 will come to an end. 138 will come to an end.
Will move an application. Simple as that.
If you will.
Complaint filed by the petitioner on the 138.
Shall not impede the trial or offence under section 138 NIA.
Filed by the petitioner.
Filed by the petitioner, appellant. Yes.
In 23, before my friend begins, the 18th stage may continue.
We already continue. Yes.
In item 33, before my friend begins, I have filed my counter this morning. If my lord could take it up next week. The only issue is
your counter.
Counter, I filed it this morning. I received late. The fault is entirely mine. I could be accommodated by 1 week.
Your rejoinder is not required?
Yes, not required.
Then let the counter filed by the respondent be placed on record. Yes, what do you say?
Page 17 of the impugned order, paragraph 16. The government in charge and responsible is not found in the complaint is a finding. Whereas in page number 58, paragraph 2, there is an government. If every person is in charge and responsible, is C. There is an allegation. Your lordship may see.
No, we are not seeing. Why are you arguing when he is not in a position to argue? We don't have the counter.
This is a society, not a company, Mr. Counsel. This is a society, not a company.
Yes,
the concept is different.
Section 305 of this.
After 2 weeks. Yes.
Also different. Any specific?
It will come immediately after 2 weeks. Yes. Date doesn't. Some date. Next 2 weeks ke baad. Yes.
May please your lordships, my lords, I beg to appear for the petitioner. I apologize for appearing on the virtual, my lords. There was some personal difficulty today. I could not come immediately to the court. Unless the counter has been filed, if lordships wants, I can place the impugned judgment before your lordships. I can start my lords on virtual mode, my lords. I can put the... I'm ready to start, my lords. I just wanted to apologize for being on virtual mode, my lords. That's it.
You come and I do physically.
Lordships may have it on Tuesday, my lords. I'm sorry, my lords. There was some bereavement in the extended family. I have to go there, my lords. That's the only reason I could not come. Lordships may have it next Tuesday. I'll be there physically. That's why I apologize in the beginning, my lords. It's an unforeseen circumstance last night, my lords.
Learned counsel for the petitioner. wants to argue the matter physically. Post the matter on 10th March.
Very well, my lords. My lords, may I just make a request, although it is on the adjournment is at my behest, my lords. The trial court is insisting on my appearance, my lords. Lordship may only very well, my lord. I'll not push for it. I will be there on 10th March. I'm sorry for this one.
Item 35.
Yes, my lords, I appear on behalf of the petitioner. The state was to file counsel on the last day of hearing. It is yet to be.
17 years में कैंसर हो गया बोलता है. State PC का है. सब का.
Senior from.
You bring him.
Very well. My lord, anyway, a senior from Bangalore is to argue the matter. It may be listed in the second week of March.
No, but at least he should say whether he wants to file counter or not.
Very well.
Whether record of the trial court is summoned.
Not so far, my lords.
Let him come. Let him come.
Very good. So wait.
Ask him.
Basically, cost. We can be some confinement.
4 weeks for counsel.
Item 37.
My lords, I am appearing for the petitioner, my lords. I am requesting for short accommodation, my lords. The Argo counseling is unwell, my lords. I am requesting for 1 week's time, my lords.
The state has taken the accommodation, let me see the orders.
I am just seeking for 1 week's time, my lords. That's it.
Look at the last order was 6th of October. The lordships granted them a last opportunity. Even prior to that, on September, 9th of September also, they showed time, lordships.
I apologize, my lords.
2022, they are just taking time again and again, which is not a first problem.
My lords, I am requesting for just 1 week, my lord. That's it.
And may I be lordship, because I have filed my application for implement and direction. My grievance is this. My complaint is,
if we are not able to decide in your absence, then we'll allow the implement.
You know, at least, because for the last, yes,
if we are not satisfied with the assistance rendered by him, we will allow for implement.
My case is not that, it's not simply sitter. In fact, I succeeded on the premise.
You convince him.
Other party, but
you convince him, otherwise we'll post it after summer vacation.
No, I'm saying,
because if the implement is allowed, then he will file counter, then a rejoinder to the counter, and it will go on.
Plus, the implement.
At least 6 months package.
Plus, I'm only saying submitting.
Or else, your lordship, I will not file any counter affidavit. Your lordship, just because I am similarly placed, I have my writ petition is allowed.
What for you are filing implement if you don't want to file any counter?
You don't want.
You are supporting the state or the
respondent.
He is already protecting his interest.
My problem. 1 minute.
Application for implement is rejected.
No, your lordship may not, because I have already my petition is allowed on the basis of an impugned order. When that order is not being implemented for the last 4 years, I filed a content petition. My content petition was not kept on hold because of the pendency. That's all difficult. In employment,
he wants to bypass that particular stage because state has filed an appeal against my orders. Now it is my petition.
You not say would just
anyway. We'll consider.
Please consider.
Coming Tuesday. Coming Tuesday.
Please.
Much obliged.
Yes, for minutes.
Yes.
Next 28.
Yes.
Announcement.
Yes. There is not here also.
Item 39.
39 is a contempt matter, Lordships.
Yes.
Implement order passed by this court 2 years back. We are still struggling to get the order implemented.
Lordship, Lordship, may I mention, Lordship, I'm referring for the state.
Class.
Yes.
Clear cut order and what they have done.
Clear cut injury, you see.
That injury is there, Lordship.
Lordship, again, Lordship, we have complied with the order. Only thing what is left is the some areas
Then how it is full compliance, Mr. Borakati?
Sir, my instructions are that it will be, it might have been already cleared. Give me 2 weeks time, I'll update Lordship with that.
Compliance affidavit. Affidavit he has filed.
Yes, please kindly come to page.
What remains to be complied?
Himself says that.
Lordship, some areas are to be paid to them.
How much time will
I am told that it is 2 weeks time, Lordship, I will file affidavit on that.
And that is one aspect. And another aspect is everyone has been provincialized with effect from 1/1/2013. These 6 people have been randomly given a date 1/6/2016.
That would be a separate cause of action, Mr. Borakati. That can't be contempt.
So certainly, Lordship, because Lordship.
Alright, let him file at least to get the areas, then we'll see.
Yes, very good.
Lordship, give me 2 weeks time, I will do it, Lordship.
Sri Devojit Borakati. Council Borkakati. The council.
Yes, Lordship.
Contender submits that what has been paid?
Pending areas.
Nothing has been paid. Pending areas shall be paid to the petitioner within 2 weeks, and he shall file compliance affidavit.
Lordship.
Matter. On recording the above submission, let the matter be posted on 24th February.
Yes.
Grateful. Very good.
40 minutes and plus 40 I am entering appearance on behalf of some of the defendants. But this pertains to contempt minutes.
Service is incomplete. Service is incomplete for respondent number 8 and 9. Both are deceased.
Yes.
Not may kindly permit us to take steps with regard to that.
Let unserved respondent number, let just notice be issued.
8 and 9 died.
They will take a step for bringing LRs on record.
No, my lord, I'll take steps.
Then you will have to take steps.
Let steps be taken for bringing on record the legal heirs of deceased respondent number 8 and 9.
Thus, in the meanwhile, I'll undertake to file wakalat on behalf of three defendants for which I have got malus.
Which respondent?
Defendant number 1, 2, 3, 5, 1, 2, 3, and Lordship 5, 6, 7. 8, 9 are no more.
1, 2, 3, 5,
6, 7. I have got instructions.
What about 4?
Plus 4 is in hospital, I have been informed. I have oral instruction that I may get a wakalat on behalf of them also.
1, 2, 3, so also. You have filed wakalat?
No, yes, I have not. I'll file. I've got the wakalat.
Learned counsel appearing for so and so. You want to file counter?
Yes, I want to say propose one thing, Malas. This pertains to the payment. Malas, there is one subsequent purchaser who was a party before the court in SLP also and as well before the High Court. Let him be pleaded. He had offered to pay on because the property was.
Say so in the affidavit.
I'll say so in the affidavit. If you can
to file counter affidavit within 2 weeks. Put the matter after 3 weeks.
If he can be pleaded, he can pay the amount. That's what is our instruction because he has already given them offer. Now, as on date, my oral instruction.
All right, you take this plea in your affidavit.
I'll take it. Very well.
And you think over it, Mr. Counsel?
It's a contempt petition. He has not committed contempt. Why should he be pleaded?
No, it's because he was a party before this honorable court. Only thing in
whether the contempt is committed by him or by you.
No, by us. But
then how can we say?
I will
contempt petition.
I'll put that in affidavit.
Yes, an application if you want to shift.
Contempt petition, we can join anybody as respondent provided we have an impression that he is also committed contempt.
He has not,
Otherwise-
but he wants to pay on their behalf because of.
Yes, yes.
I will put this in. Very good, grateful.
41.
Yes,
For the respondent for it,
yes.
that's, the charge sheet mentions the proposed punishment, and also I have not been show cause to file my reply.
There is no inquiry without.
In 1983.
Clean case.
Petitioner 41. No one best. No password.
Copy है पहले. आगे फोटो सी मतलब.
No, 40.
Yes.
Please, Your Lordship. The respondent is beneficiary of compassionate appointment, though he has been acquitted in that FIR subsequently. But the issue, my lords may have page number 40, that is the affidavit file. Pursuant to
He
his
was
appointment-
facing an NDPS case.
Please, my lords.
It was disclosed also. That was disclosed.
That has not been disclosed. The FIR number and the trial has not been disclosed. It was disclosed in a very cryptic manner, though he stated that I am facing a trial, but in a very cryptic manner, my
You should have
lord.
verified. You should have verified.
My lords,
And acquittal is by what mode? Acquittal is a clean acquittal.
acquittal after framing charges, my lords.
Is it a clean
Yes, my
acquittal
lord.
or what is it?
Yes.
Madam, it's an only acquittal. It doesn't say clean acquittal.
Where is the judgment? Where is the judgment of the matter?
That has been placed by the.
See, otherwise there is no disqualification. It is not that he
Otherwise,
is.
my
lord,
lord,
my lord, page 8 of.
Please, my lord.
1 minute, Mr.
Yes, my lord. I'm
Otherwise,
sorry.
my lord, he was entitled for compassionate appointment. He was granted also.
Page 40, he mentioned one case. You should have sought a better affidavit from him.
Correct, my lord. That should have been, but
Yes.
without having FIR.
Not that he has tell this
That
information.
FIR number he gives, he said that case is under trial.
Then, my lord, he does not give FIR number.
Oh, please come, page 41. Verification.
My lord, this is the report filed. My lord, page 40, para number 5, he discloses that deponent is under trial in one case, but the said case has not been disposed until date. So, my lord, the purpose of having this affidavit and a disclosure is giving clean number and details.
Little different from routine recruitment. Case of compacted appointment.
I have
And the
sympathy for him, my lord.
fact that he has been acquitted now. Mr. Counsel, Mr. Rana, have you filed the acquittal judgment?
Yes, my lord. My lord may see page 8 of the application for filing additional documents. My lords, we have placed it on record. Annexure A1, it starts at page 8. My lord, application for placing on record additional documents.
Let us see.
Page?
My lord, page 8, annexure A1.
This was on 7th October 2025.
Yes, my lord. Yes, my lord. And now my lords may see page 31, my lord, para 36.
So you are riding as a pillion rider. If narcotic was recovered from the pocket of the driver,
Please, my lord.
and the
Yes, my
motorcycle
lord.
was owned by you.
No, my
You
lord.
were the owner of the motorcycle.
My lord.
And that person has been convicted, my lord.
Wait a minute.
Yes, my lord. That person has been convicted. In plea bargain, he sought lesser punishment.
Para 37.
My lord, para 36 at page 31, my lords. My lords, may I read para 36? In the present case, no recovery has been effected from co-accused Arsam Malik, nor is there any material to suggest that his conscious possession or involvement in
Who was the owner? Was the motorcycle owned by this this person? Was he the registered owner? Any finding to that effect? नहीं सर motorcycle confiscation का order नहीं है.
I don't think, my lord, that has been. My lord, the only connection which I was. My lord, the only connection was that the mobile tower location of both the A1 and A2 was one. To which
That obviously, since they were traveling together.
yes, my lord, to which the trial court said that merely because he was found to be in an area where A1 was also traveling would not be a reason.
No prior meeting, no prior knowledge.
Nothing, my lord. Nothing, my lord. It has been absolutely established that I had no prior connection with the first accused, and my lord, therefore, there was no credible evidence on record to show that the accused was involved in the transportation of the contraband by accused Mohammed Sohail. Mohammed Sohail stands, my lord, convicted.
All right, take it to President. He'll do that. I have that compassion for him, my lord, that
Otherwise, also the acquittal is on the ground. He had no knowledge at all. The other guy was perhaps an addict.
Considering that the petitioner had, the respondent had disclosed one criminal case pending against him at the time of securing compassionate appointment, and in the said case, and at a later stage, he has been acquitted in the said offence. We are not inclined to interfere with the orders passed by the High Court.
Clean acquittal.
He is granted clean acquittal. Has been granted clean acquittal. We are not inclined to interfere.
Lord, yes, may request that if my lord may consider saying a line with regard to the salary which he may file a litigation.
Whatever the High Court has directed, we are not interfering.
What salary is?
Salary for the period during which you are dragging him here. Should have thought it before coming to this court.
The idea was only just to avoid annual litigation.
Yes,
grateful.
Very well, my lords. Deeply grateful. Deeply grateful.
43 notices were issued on 19 December. Somebody has entered appearance, they have to file reply.
It's 2, 3, 4 and 5. Let's say I filed Vakalatnama yesterday, the day before yesterday.
Because I appear for respondent 1.
So I will file my counter minutes. Should they give me some?
How much time? 4 weeks for count.
Yes, some date.
You will find a date after 4 weeks.
Yes. Let's permit us to give physical appearance.
I will give
Then petition, my lord, I would recall, my lord, 10th February 2022, my lord, this building got collapsed somewhere in Gurgaon.
What?
And 4th January order, my lord had passed an order.
Contempt petition.
Yes, my lord. So today happens to be almost 4 years for this building to get collapsed. And the builder has taken no steps, my lord. 4th January 2024 was the order passed by this honorable court. They had taken 18 months to apply for a permission, and permission has been declined for the reason that the form which they have submitted is not signed either by architect or by them. What kind of role is this, my lord? They are arm twisting all the owners. Owners are, some of them are staying there, some of them are vacated. Those who are staying there have no place to go. Rent was fixed at 40,000 rupees, my lord, which again they have not paid. This is the situation, my lord.
Yes.
I'm led by my senior. I appear for respondent number 1 and 2. They are also physically present here in court. I'm led by my senior, Mr. Ahmaram Nantari, seeking a short pass to her. Also, reply is ready. We seek some time to put it on record.
You better place on record your affidavit.
My lord, if I may point out, my lord, I am appearing online for the state and the officers, my lord. Now, my lord, it seems the petitioners are the people, my lord, who are still staying in the apartments. As per the directions of my lords, my lord, in the judgment, contempt of which is being challenged, my lord, they were supposed to vacate it. Then the builder was directed to do the construction in a timely manner. We were directed to fix the rent, which we did, my lord. And my lord, accordingly, they were supposed to get their flats. Now, my lord, it is not reflecting in the petition clearly whether these petitioners are the one who are staying inside the apartment and asking for reconstruction, or they have shifted from there, my lord. So first and foremost, my lord, they must clarify that. Apart from that, my lord, unless and until, my lord, the entire area will be vacated, it will not be possible for, my lord, either the builder or the state, my lord, to demolish and reconstruct.
Are you vacated?
Yeah, my lords, there are some of them have vacated, some of them have not vacated.
Then how the
Please give a pointed answer, counsel. Please give a pointed answer.
The builder has applied for seeking permission to reconstruct July 2025. Kindly bear with me. What happens is, my lords, so had I vacated, where do I go? He doesn't pay me the rent. He doesn't agree for the construction. He doesn't have permission. Now the final point. Final point is he doesn't want to reconstruct the same tower. He wants the additional FAR to raise more flats there on the same property and then make money and also charge us for reconstructing.
So if he pays you the rent, you are ready to move out?
Yes, sir. Yes. That we have been telling him.
Milots, the 4-1 order against which there is contempt, if Milots may kindly read the order.
You read that?
Yes, Milots, the order says that I am supposed to pay the rent to them upon reconstruction. Milots.
No,
No.
commencement
It's
of
not upon reconstruction.
commencement of. So if you delay, you don't even seek permission to raise construction.
Milots, there is another matter before an alternate bench of my lords.
Forget about that.
Milots, there is a stay that is
We are not
concerned.
concerned. We are not concerned.
Payment of the rent.
We are not concerned.
Milots,
You can't do that.
I am led by my senior.
Stay at your instance.
Passover may be granted.
Okay, who has obtained stay?
Milots, there is this, Milots, in Shashikant's
Who
matter.
has obtained stay?
The flat owners, Milots.
On what?
Milots,
My lord, there is another batch, my lord. There is another batch of petitions. My lord, if I may just give a background of the entire case.
We are
What happened
concerned
was
with contempt of our order.
only contempt, my lord. So, my lord, I request, my
Forget about
lord.
any other matter which is pending in different benches.
Definitely, my lord. Definitely. Now, my lord, how they are pointing
You file
out.
counter,
yes,
then they will file under
yes,
2 weeks.
Sir, at least pass a rent order. People are from 4 years.
We'll do it in one go.
So, आपका order, like your order, in which 5 towers.
You have a lawyer appearing for you.
I am the petitioner, sir. Every
If a lawyer representing you,
sir, they are
2 weeks for counter,
so at least pass rent. I'll convey.
1 week for yonder thereafter. Post on 12th March.
Very well, my lord.
Yes.
Item 45.
If for respondent's counsel, my lord, the respondent number 1 had met with an accident. Yesterday he has signed the affidavit. We will file the counter today evening or tomorrow early morning. 2 weeks time maybe.
What? Counter.
Counter, my lord. For the
We have already signed. Why 2 weeks?
affidavit has been, he has sent from Bangalore. We will file it today evening, my lord.
2 weeks for counter.
Yes, sir.
Item 50.
My lords, it's a complainant appeal. As per the last order, the state has to verify the death of
I appear for the statement. Unless the respondent number 1 has passed away, Manoj. I appear for the statement.
Respondent number 1 has passed away.
Yes, Manoj.
Yes.
The
Appellant has also
that
died.
report is already there on.
My lord, this is a complainant appeal. R1 has passed away, R2, R3 are still.
Manoj will have to hear the appeal court.
and-
whether accused will be acquitted, Manoj.
So, my lord's a criminal appeal, my lords, has to be put on.
Admit करके ये नहीं।
Respondent number 1 has died.
Wait हो जाएगी उसकी expect.
You are the
I'm the complainant.
Complainant's appeal against that purpose.
he is the only accused.
No, my lords, 2 more, R2 and R3.
My lords, I appear for R3, my lord.
1 and 2, in item number 50. 50, respondent 1 has died, I am for respondent submissions. I do not know whether the death certificate.
What about respondent number 3?
My lords, I appear for respondent number 3, my
Death
lord.
certificate of respondent number 1 is filed.
Not yet filed, my lords.
Manoj, we have carried
My
it
lords, I
because
appear for respondent number 3. However, due
Carry
to
with you, file it in the
File it on record.
I'll give it back.
It's not on record, but right now we have the physical copies, your lord.
You have already filed it?
Yes, your lordship.
No, when?
But it's not on record.
When have you filed?
When did you place it on record?
Your lordship, yesterday.
Yesterday.
Your lordship permitting, I can file it. Because
They have already filed it, Mr. Counsel. They have already filed it.
Office report says you have not filed any document.
Not filed.
Yesterday.
You have filed yesterday.
Yes,
Are you sure?
yes, your lordship. Yesterday.
Because the office report is also of 10th.
Let the death certificate of respondent number 1 be placed on record within a week. Post the criminal appeal for final hearing after. Yes.
My lords, may I make a request as well? I appear for respondent number 3. We have not been able to get in touch with respondent number 3 for quite some time. If the state could also verify their status.
I will see when the matter is heard.
Grateful, my lords.
कोर्ट भी इसका टाइम है सर उसमें वेरिफिकेशन
Possible matters.
तो फिर जाएगा
Next, kindly appreciate, there was a decree by the court.
2006, death has taken place.
And 7,
You applied in 2017.
no 7, there was a decree, kindly see, there was a decree passed by the civil court, but in which SCCL was a party. And SCCL went in appeal, modified the order.
No, but on what date you applied? There may be a decree, but
Immediately.
application. First application in 2007. Who was that application? Because the finding is against you that you applied in 2017.
Page 43. Where is that application of yours?
Application is not there, but kindly see page, my lord, it will, page 50.
Where do you say that you applied in 2007?
Kindly see page 50, my lord, page 50. SCCL went in appeal matrimonial challenge after
Forget about that appeal. That appeal was not for competent appointment.
Kindly see this. I will read only 2 lines. my lord.
Cause of action may arise in your favor in 2007.
Kindly see this. Page 50. Last line. SCCL went in appeal, modified their decree. Decree says you give the appointment.
Decree is to that.
And he said you go and declare your legal status. When it was a party.
Where is the decree?
Page, kindly see page 50, bottom line. Consequently, the appeal deserves to be allowed in the hereby allowed judgment passed by family court such and such in civil suit is modified to the extent that class 4 of the decree will not be binding of the appellant unless legal status of respondent number that is legally valid by the side.
Finding it is
You get declared your legal status. And kindly see, according to decree in which the party Santi Devi was to be given compassionate appointment. In compromise decree, 2007 court has passed order.
Where is that?
Page 45.
Kindly see
Page 45. Where is the declaration about your compassionate appointment?
In gross working on post of front, so the plaintiff Shanti Devi shall be rightful claimant to receive 1,500 by so.
This is the decree. Compromise. So they got modified it. Well, get your declared your status.
After 8 years.
It is enabling.
Some directions.
Notice.
Did you?
Item 13.
Yes.
In item 13, my lord,
Yes.
surrender as per the last order of this honorable court. And in this case, the submission is the second.
No surrender certificate.
Yes, my lord, we filed the surrender certificate also, office report also.
Case 320.
The honorable pleased to take the application and the surrender certificate has been filed. Well, the our cases are section 399 on defaulty requires 5 and more.
They fought on the spot.
No, my lord, that's the thing. 5 and more, there were only the eyewitnesses, only one eyewitness, 2 are neighbors. The only eyewitness also says that only 4 person was there. My lord, just say 6 page 64, 67, my lord. No, page 6, starts at 66.
Huh?
Starts at 66. I just read it.
What is the finding of the trial court? Does the trial court say that there was one unknown man?
But yes, my lord, trial court acquit 4th person, entity not established.
He ran away.
Convict 1 to 4, my
Ran
lord.
away.
Page 219, my lord. The trial court convict only 4, identity of person is not confirmed. This, my lord, the only eyewitness, page 66, the one who is filed the company also, under this court. Only, my lord, he was 25 years old.
Months.
My lord, only 2 months, my lord, I was throughout on the bail and exemption was granted to me, and I was 26 of 8, my lord, in 2011, my lord, under section 4 of probation of offender X, my lord. No exemption, no, my lord, no exemption throughout on bail, exemption, throughout on bail.
Considering that the petitioner was on bail during trial as also during pendency of appeal before the High Court, we are inclined to suspend the sentence and release the petitioner on bail. Notice it only. Very careless.
Really good.
First up.
His name entitles him to bail.
Yes.
Accordingly, the sentence imposed upon the opponent is suspended. Released on bail, subject to the terms and conditions imposed by the trial court. Record of the trial court be summoned. Post the appeal on 4th May.
Notice
Notice.
surrendered in pursuance of the order dated 12/11 to 25. The custody
Petitioner has already surrendered and surrender certificate is signed. उसके बाद इसको notice.
Much obliged.
Item 21.
My lord, I am seeking some accommodation, my lord. I'm being led by learned ASG is the way. I'm seeking a short accommodation, my lord.
Yes.
I'm being led by learned ASG, she is held up in court too, my lord.
Yes. At the request of the counsel for the opponent post after 4 weeks.
Right, my lord.
Yes.
Can I file a list of dates and short submission?
Yes.
There are 3 or 4 matters.
Yes, parties may file list of dates and written submission. Yes.
Great.
Item 35.
My lord, it was passed over because nobody appeared on the file.
They are not appearing.
File
Let record of the trial court be summoned.
exemption from surrendering to continue, my lord.
Post the matter on 5th May. In the meanwhile, exemption from surrender allowed in favor of petitioner shall continue.
So wait.
Item 38.
Last date of hearing asked me to make some charge. Last date of hearing asked me. The case of amputation, the last.
Amputation.
Artificial limb.
Yes, artificial limb. And in one of the matter, my lord, so
you are awarded 5,98,000.
By the and enhanced to 9,86,000, my lords. Criminal was awarded
598, then 986.
986, my lords. The error is, my lords, High Court was taken only 25% of the disability, my lords, and the income was taken as 10,000, my lords.
What was your vocation?
I am a cook, my lords, in the hotel. I have not filed any.
Vocation is of leg.
Yes, my lords, I filed the photographs of, if you see the page number, my lords, photographs are already there.
You can, leg amputation, Ms. Counsel, leg amputation can very well carry on the work of a cook.
That's
able to,
yes, my lord, that's for artificial limb. Can you see the page number?
To travel a photograph while cooking.
It is 28 page number. I have to stand long already 25%. But can you see the page number 28?
Counsel, There are people who are running marathons with both amputation.
That's I would like to show page number 28 minutes. That's here right now for the this artificial limb and expenses. I given a judgment of last hearing, my lords. Where my lords, the expenses of artificial
limb and replacement. That you will get, no doubt.
That's and disability, my lords. If it is considered that thing, my lords, it will be. I given a judgment.
12,500 has already been taken as monthly income.
The 18 accident, my lords. For chef, it was really very lower side, my lords. 8,000. And it's a 2018 accident. Minimum might have 25 to 30,000 everyone earns. Minimum even many wages were taken. So the income
Future prospect also 25% taken.
Yes, only 25%. And the doctor exactly given, my lords, is 70% disability.
Some you say, what more you want? 1986 around, that means 10. We may increase by 2 lakhs more.
My lords, it will artificial limit will cost.
Replacement of cost.
One case, my lords, have given 15 lakhs for artificial limit.
For that I can read page number 37.
Required to be replaced.
Regarding that, there is
for 5 years.
This finding by tribunal, my lords, page number 37, if my lords may have it. There is finding of tribunal, my lords, that the doctor himself has said that page 37, my lords.
What has the doctor said?
Lords, I will read it. Para 40.
You just state. Not need to read.
Doctor has stated that petitioner needs fixing of artificial limb except the petitioner does not require any future treatment.
So obviously, fixing of limb, that
which para you read?
His life has been compromised.
Para 14 and not
subsequent of the High Court.
Replacement,
yes, no, replacement
of the artificial limb.
Para 14 tribunal notes. Para
it's a costly business. If you want a good prosthetic limb, it's a costly business.
5 lakhs by them, my lords, before the
judgment I given to my lords, there, my lords, refer the patient to the refer the patient to
seeking
my lords,
future prospect.
Future prospect is already taken, my lords.
Already taken.
My lords. So only 12,500 what the High Court taken it, at least, my lords, that took 15,000.
No, but what is the basis?
That's a cook.
You have to have some evidence.
And please, that's why
on the date of incident.
That's why, my lords, 30,000.
The minimum salary of a cook is 15,000.
That's why 12,500
is reasonable enough.
Notional income has been taken.
I will leave it, my lord. Notional income has taken, my lord. That's 15,000 will be correct amount in according to me. 50,000. Anyone 25 to 30.
That according to you,
can't be random. Whether you come prepared with some judgment which says that the income of cook should be taken to be.
I said for the cook, my level best. What about other things I have given all judgments.
What about the minimum wages at table? Do you have that table?
Yes.
Are you carrying the table? That would be. He may take him to be a skilled labor. But then what was the salary at that point?
Because 12,500 was the skilled labor.
12,500.
Skilled labor as per the Justice Karol's judgment is as per the skilled employee in 2010 accident he is taken as a 12,000 my lords. I have a judgment in that point.
There is a table under the minimum wages act. You have to go by that.
You produce that notification. That is a statutory notification. We can consider that if it is placed on record.
Tomorrow only I will. Tomorrow, next week, anytime.
Learned counsel for the petitioner is permitted to place on record
skilled employees
the notification as applicable on the relevant date, showing the minimum wage for a skilled laborer, that is a cook. Yes.
Next week.
Post. Next week you want? Next week. Post me next week.
Item 41.
Well, take data.
For the respondent.
Just a minute. आज 10th ना 24th को करना 20.
Item 41 and for the respondent.
First item of कोई नहीं था. Discussion report करनी होगा. You have what was
the case of illegal
termination. RSRTC.
शर्मा पकड़ा होता है
शर्मा RSRTC.
Jurisdiction of the civil court has been upheld.
That's the only argument which
None appears for the petitioner in both the rounds. The SLP is dismissed for want of prosecution.
merit